All right, so we are getting started. We have a couple of people coming in, our early attendees. Well, technically, they're on-time attendees. And we're expecting one additional person to join. I'm seeing her here. Welcome, welcome everybody. Georgia, we're actively promoting you to panelists, so we should be seeing you shortly. There you go. Excellent. I'm really happy to have everyone here this evening. I just want to give a couple more persons an opportunity to join. Wonderful. Thank you guys so much.
While we're waiting on the other persons to join, I know I'm panelists already, but I like the idea of promotions. Can I be promoted to something as well?
Yes, Chukwuemeka, since you're putting it out there, you possibly also have what you want to be promoted to. Locked away and ready, right? Thanks so much, Anne-Marie. Welcome. Great to see you as well, Andrew. This is going to be a really great conversation. And guys, this is the culmination of all the talks. So no pressure, panelists, but every single talk before this one has been leading up to this very moment. I know that makes you feel extra special. Excellent. All right, guys. So yes, and you're accurate, Andrew. This is an all-star panel that we have tonight. We're talking about all things data privacy rights. And we are hoping that you guys have brought your notebooks so that you can get all of the insights and information that is going to be shared tonight, because yesterday at rehearsal, I can tell you guys, I literally was taking notes because I was learning so much just based on the insights that were being shared, you know, from the persons on the panel. And these are the individuals that have been actively working at ensuring that we, the society, whether it is you're a business person or you're a layman, you're an individual that is just participating in day-to-day life, these are the individuals that have been working either behind the scenes or in forums like this, or even in government directly, with helping us to see, achieve, experience the rights that we have on a legal as well as just, you know, general human being level as it relates to our data, its protection and its privacy. So joining me tonight, I have legal expert Georgia Henlin of Henlin, Gibson, Henlin, and attorney at law. I also have Chukwuemeka, who is also an attorney at law. So we have the legal side fully locked up and ready. So make sure you have all of those questions, those material pieces of conversation that you want brought to the fore. And additionally, I have founder of Design Privacy as well as industry thought leader Matthew McNaughton, and who is also founder of Slashroots Foundation, and Trevor Forrest, who is CEO of 876 Solutions, as well as an expert in all things that I like to say, all things that need to be demystified many times as it relates to when it comes to things happening in government. I think having served in that capacity, a lot of times, you know, I lean on Trevor just to get the simplified insights on it, right? So, so thank you guys so much for joining tonight. We're going to be having a conversation around privacy, and the way that we want to contextualize this, guys, is around three core context areas. So the discussion is going to be driven around, first of all, accountability, responsibility, and trust and security. Now, why is it important for us to contextualize this discussion? Because truth be told, we could be here talking about this aspect, this angle all night long, right? Instead, what we're going to do is we're going to zone in on some of the key areas that we believe you as citizens need to be aware of, both in terms of what your rights and obligations are, as well as some thoughts that we have for the government and how we think that they should be observing accountability and responsibility and their awareness to building and maintaining the trust of the society as we move towards this digital age. So welcome again, panelists. Thank you so much. I'm going to jump right in and start off with the conversation around accountability. Now, when we started this discussion, it was not too long on the heels of the JamCOVID vulnerability issue that was being discussed on many different levels in many different forums. And the whole discussion kind of culminated, especially over the last few weeks, that, you know, it's not so much that these breaches or instances, let's not say it was a breach, it's not necessarily that these issues are not going to come up. We're going to have cybersecurity issues because we are in that space of the information age, right? But how do you handle the issues when they occur? What are the levels of accountability that are being observed at both the government level as well as at the societal level? So when we start off talking about accountability, what we want to focus on is not how should we hold the government accountable, but what exactly does the law provide for us? What does the current data protection law do for us? And I think that it would be great if we could kick that off with Georgia, just giving us some general insights on, from an accountability standpoint, you know, what do we have available to us as it stands right now?
Well, I think that people would have heard enough about what the Data Protection Act says. So it talks about the standards and the principles on which you can access and process personal data. We know that data protection is really a means by which you access data because individuals are inherently entitled to own and control their data, and its privacy basically is protected by the Constitution. We also know that from the Data Protection Act, that data subjects, meaning the identifiable or living person whose information, who can be identified from information, that's a data subject. We know that that data subject, because of his or her inherent right to his or her data, they have certain rights of access and control in terms of how controllers, those who control their data, process their data, how long they keep it, how much they take. So when you look at it in that context, then you say, then if I allow an entity, for example, government, to have access to that data, what level of accountability should they have in relation to this data? And the way in which the Data Protection Act treats with accountability is that it is not enough to say that you are complying with these principles of processing data. You must also be able to demonstrate that you are complying with it. And by that, they tend to mean that you have to have policies around things like security. You have to have policies around things like information being given to persons in relation to why you're collecting their data, how you are using it, how long you're going to use it for, and also not to be using it for more than you say that you're going to be using it for. So the whole idea that when we talk about accountability is really that whoever has the data, whether it's government or private sector, they have to demonstrate that they treat with it in a particular way. And when I say demonstrate, is that when we get to the point when the Data Protection Act comes into force, the Information Commissioner will be coming in and they'll be looking to say, okay, so you say that you are abiding by these principles, show me. So that's how it's going to work in the future. I don't want to go into the whole aspect of security because I know that that is Trevor's forte.
Well, you actually raised a couple of really good points there, right? Because I recall the questions that were raised or have been raised, especially as an investigation is going on, you know, that some people think that the law is now active because, you know, you'll hear about things in the news and you'll see law passed in parliament, etc. And it feels like, okay, so I should have this protection. No, but based on what you're saying, it is not yet in effect, even though it was passed in 2020.
Yes. Mm-hmm. It's not yet enforced. It's not yet enforced. There is a provision in it that says that it will come in force on a date to be published in the Gazette. And that has not yet happened.
If I may comment on that, one thing I usually share with persons in explaining that scenario is, imagine if police were to come and kick off your door and tear down your place, so them searching for something, and they do not show you a search warrant. Inherently, you would know that they breached your right to privacy, and you don't need to be a constitutional lawyer or a privacy expert or anything to know that your privacy has been breached. You would inherently know that. If it is the same police were to come back the next day with a search warrant presented to you and then conduct a search, it would be still a restriction of your right to privacy. The only difference is that that restriction to the right to privacy would have been done in accordance with the law. That police officer would have gone to court, appeared before a JP, presented certain information, and said, under this legislation, I need to get a search warrant. Here's a proof, the basis of my suspicion. And then that legislation would then give that justice of the peace the power to issue that search warrant. When that police officer comes to your door now, he would be restricting your right to privacy in accordance with the law. So the analogy is, because we're speaking about a constitutional right, your duty to protect the personal data that you're processing doesn't singularly arise from the legislation. Your duty to, what the Chief Justice said is that any unauthorized use of information may well be a breach of their constitutional right to privacy. So what the legislation actually does, it tells you how you can infringe one's right to informational privacy in accordance with the law. So the Data Protection Act really allows you to conduct your business. It is a constitution that places that onus on you to ensure you are processing that personal data in a safe, secure, transparent, and accountable way.
Okay, that's an interesting spin. I won't recap yet. I see Matthew has his hand up. Go ahead, Matthew.
Yeah, just building on a few points that both Georgia and Chuck have mentioned. So I think one important one, kind of an extension of the point that Georgia mentioned, is that the Data Protection Act itself, at whatever date that it becomes brought into force, to be determined by the minister when it's gazetted, there is a 2-year transition period by which any data controller in the Jamaican context has to comply with it. And so in that intervening period, that means that even the processing requirements, the standards for processing, the rights that data subjects will have in relation to the processing of that data, all data controllers will effectively have 2 years to become compliant with those requirements. So it's an important one for us to think about as we contemplate, all right, just as you mentioned, Stacey, when people say, oh, but don't the Data Protection Act did pass last year, don't I have these kind of rights? And so one, we need to, the law has not been brought into force. And then even when it is brought into force, there's going to be a 2-year period, but before effectively the things that the law stipulates, people will have to comply. And so that's an important thing for all of us to be aware of. But then even, I would say, just one quick point that I'll add on that is that an interesting and important one of, well, if we were operating in a framework where the Data Protection Act was both in force and applicable to all of the, all compliance was required, then one of the things that would the government have had to do, or any organization that's in that role, is that they would have had to notify all of the data subjects that would have been potentially affected by that kind of, breach, to let them know, this thing has happened. your information may have been exposed, and here are the specific actions that we are taking to rectify that information. And that's an obligation that the law now will be placing on data custodians in relation to things like security breaches, which may lead to disclosure of personal data.
Okay, I just want to see if Trevor has anything to add before I bring Georgia back in, who has her hand up now.
No, man, you see, when you have a whole heap of smart people, you know, you don't have to say too much, you know. So I'll just, you know, sit back and listen, and you know. No, but I think everything has been aptly covered by everyone as it relates to the data protection legislation and what it is meant to do. So I think, you know, there isn't too much more for me to say on that. I think when we get a little further down this wicket, I'll have a little more to contribute.
Okay, thank you very much. Now, Georgia, since you're getting ready to address the points that were raised, again, I just want to throw in there for you to also consider. Now that we know that people don't have to become compliant, so let's say that it doesn't get put in effect until 2025, and you know, 2 years, we have that 2-year window between now and whenever that happens. What do we do in the meantime? You know, if some,
Okay.
let's have more. Yeah.
Okay, so I just wanted to add a gloss, as we say, on what Matthew indicated in relation to the JamCOVID. So I call it incident, and a lot of people call it a breach. And that is very important for data protection and privacy, because in relation to a data security incident, you don't have to make a notification, whereas in relation to a breach, you must. And the distinction between the two is that in relation to an incident, there might very well be, say, what we'd call an attempt to, or maybe even someone might have gone in. However, the issue is whether they exfiltrated anything. So if they didn't take anything, or personal information was not placed at risk, then it's an incident. To the extent that personal information was lost, then that's where you get the breach. And that distinction is extremely important for business owners to understand, because of the consequences of a breach. One of the other things that I learned as well as I was going through data breach on an occasion, and it is always recommended, for example, that a lawyer is present and is doing most of the questioning and finding out what is happening. The reason for that is that if you have your internal breach incident or breach team dealing with the matter, that is not protected by legal professional privilege. But once you're doing all of those queries through a lawyer, then that is protected by legal professional privilege. I just thought I'd add that on what Matthew said. Now, to what you have asked in relation to the fact that the Data Protection Act is not yet in force, but so what are our rights? And it goes back to what Chuck was explaining. Our right to privacy is protected by the Constitution. And as he indicated in the NIDS case, it was broken out in several dimensions, and informational privacy was one of them. And it is actually clear in our charter that informational privacy in terms of communications and private communications and property and personal life, that it is protected. So for the moment, you are, as a matter of fact, subject to the proviso in the Constitution, which talks about reasonableness. You really have almost absolute right to your information. So the whole point of the Data Protection Act is to provide access to it. So it provides access to your information in accordance with the law. And that is why, because your right to your information is constitutionally protected, that is the reason you will find that the measures put in place in relation to the Data Protection Act are so stringent because it is being measured against a constitutional standard, which is, as I said, near absolute.
Okay. No, that's very clear. Thank you so much. Thank you so much for that, guys. All right, so let's continue the conversation on. I do have a couple of questions bubbling up from our attendees, which I will add to the discussion as we go along. We talked about, accountability to some extent. I think we have a better understanding now of where accountability lies and how the act supports that, timeframes as it relates to that. Now, in the interim, we do have some responsibility that we have to be taking both as citizens, as individual citizens, as well as businesses. And this can be either you're a business that is providing services, to the public, or it could be that you are a technology vendor that is providing software development services to the government, in the same way in this instance that we have been exploring over the last few weeks. What exactly are the obligations that businesses have to consider that belong to them in these situations? And then, let's talk about individuals, because we have persons on here that may not be business owners, but we do have our own responsibility as individuals, as citizens, as it relates to the security of our information and the privacy of our information. And Trevor, if you don't mind, I'd love to start that one off with you.
Yeah, sure. So in the context of purely the data protection legislation and what it is meant to do, it does create an environment where the citizen has a considerable amount of control over their data and what can be done with it. But at the same time, one of the things that citizens also need to bestow on themselves is awareness of what it is the legislation provides for them. And also the fact that, look, your information is yours. Ultimate responsibility for that information rests with you. So, although the legislation provides for a citizen to say, look, I really don't think I want to give you this bit of information, or if I give it to you, you need to, at least let me know what you're doing with it. If you don't know that, then you might get caught in a situation where you're providing information you don't need to provide, under the guise that you saw it in a form, and because it was in a form, you had to put that information there.
Well, I just want to pause a second, because when I came back from my travels and I landed, I was greeted by soldiers. Mm-hmm. So I never really feel like I have an option in this particular instance. So I think when you talk about my responsibility, it's not just one soldier, it's multiple, right? So this is, and I know we're in COVID and you go anywhere and you may have to, so I'm just trying to figure out, what does that look like? What is my responsibility in that, to say to the soldier, yo, boss, man, what do you, how do you?
So the thing about it is, it's interesting, and to look at it in a realistic sense. It's always interesting to see the reaction of a law enforcement officer when they're faced with an interaction between them and a lawyer versus them and a regular Joe, right? Because what a lot of law enforcement officers may take advantage of is people's lack of knowledge of what their rights are under the law, right? So if it is that you are well aware of what your rights are, right? In the absence of a lawyer at the time, you just need to demonstrate that you know what it is that these laws provide for you. So, I've gone to places where they ask me for information. I'm like, yeah, I don't think I want to give you that. They'll ask me for my name, then my email address, now phone number. I say, yeah, I don't think I want to give my phone number. Well, you know, then I said, and then you start talking about what laws exist, and then they're like, oh, okay. So awareness of what the law provides for you as a citizen is very important, because if you don't know, then the same thing that the law is trying to protect, you allow people to take advantage of that. So the very first thing that is always necessary is know what the law provides for you as the citizen. And I think for a variety of reasons, we either don't do enough awareness, or we don't simplify the jargon that is a law in common man words, so that you know, we're comfortable knowing when and where we can say no, right? So whenever you're being asked for information, it is always important to know from the standpoint of what your rights are, what you can or what you should give versus what you have the ability to say, you know what, I'm not giving you that. So I think that's the very first thing that needs to occur, is understanding by the citizen of what your rights are as it relates to your personal information. And I think organizations such as us and many other, you know, civil society groups and the government need to make an effort to educate people in a very simple, clear way what their rights are. If you don't do that, then you know, invariably you're going to find that somebody's going to challenge it. It's going to come out in court, and then people are going to like, really? I didn't know about that. I saw the law really stay. You know, so similar, and this has happened before. So we have in the IT industry, you know, about 4 or 5 major laws: Electronic Transactions Act, Cyber Crimes Act, Data Protection Act, Telecommunications Act, and a couple other ones. But a lot of times when people see charges laid against somebody in the context of the Cyber Crimes Act, and you're like, wow, just because a man went on social media and said this, and then somebody went and said, oh, well, that caused me sufficient distress because they know the law, and this person now is in a legal battle. People are like, really? So how many times somebody tell me one bag of things I never like on social media, but because I never know the law, I couldn't take action? Awareness of what the law provides for you. That's the major thing I'd want to put forward here.
Oh, that's excellent. Follow-ups to that?
Well, you had asked about individuals and organizations. So Trevor dealt with individuals. What I want to say in relation to organizations is that in terms of the Data Protection Act, what you'll see there is that it imposes an obligation. When we talk about the accountability, the context in which it does it is that it imposes on the organization these obligations to approach privacy by how they design their systems in relation to personal information, and it's also by default. So it's not a question of, oh, I will tailor it for this particular purpose if you can't also have, say that you're collecting information for one purpose, and then there's a bot in the background siphoning off the information for some other purpose or sending it somewhere else. So that is what they mean when they talk about this whole concept of implementing appropriate technical measures and information that you collect is safeguarded and protected.
Okay, now when you talk about design versus default, privacy by design and security by design has actually come up several times over the last few weeks as a part of this conversation. But based on where we are in the maturity of our digital transformation, I mean, you know, the design, we're already behind in the design part. So what what can companies do now? What can organizations do now to jumpstart that? Is there anything that we can offer to persons who are watching now or later that helps them to kind of jumpstart that process, because they're already behind the 8 ball. They're already in default mode then, essentially.
If I may, just to speak to the whole question of accountability and responsibilities for businesses, apart from showing practical examples, I want to just use another story or another analogy that I usually use, because I think we can even bring it to them a little more. So I'm sure a lot of us would have heard about shoes and lace in colloquial terms. And if we haven't, I'm talking about, so we're all familiar with it. Sorry, don't make a face like that. Right, sorry about that. So right now, one of our foremost entertainers has been incarcerated for murder. And that's because he had given somebody him shoes for keep, for luck. And when he was checking up on the whereabouts of him shoes, the person couldn't account for the man's shoes. He said that somebody else have it, and cartel never knows that somebody else have it and never give no permission for somebody else to have it. And he said, yo, I better get back my shoes or else. Now, the reason why I use that analogy, and you hear Matthew off using the word custodian, and you ask the question, what is the obligation of a company? Organizations have to understand that they are in possession of somebody's shoes. And there are consequences, and it may seem like a stretch, but I will make my case. There are serious consequences associated if you can't account for person's personal data. When you look from a business point of view, for one person to have the ability to tell you to stop processing data, that means your business stops. Them could have killed you if your business stopped from a business perspective. He has the power to do that. He has the power to initiate an investigation. He has the power to determine whether or not there is an infringement, and he has a power to issue that sanction, to lock down your business temporarily, nevertheless. So it is in that context, I want to just simplify that discussion about public entities' obligations and take the shine off of custodian and give you what it means to be a custodian, especially when you're dealing with personal data. That is what it means to be a custodian. When cartel give him thing for luck, when cartel asks for it, you better know that you know where it is and you never lend it out and you don't lose it. That's just to break it down into very layman terms, please.
Can I just add something to that? So, you know, and I know we're you know, the hot issue was what happened with the JamCOVID application. And one of the things that I think is very important to understand, and I was asked this question in 2 different interviews when that whole shebang was going on. The question was, who is to be held accountable for what happened? Now, at the time, everybody was up in the air about breach, and we had to kind of bring everybody back to reality and said, look, a vulnerability was discovered. There was no proof of a breach, but it is, you know, what has to be explained. It is vulnerabilities that lead to breaches. Okay, and one of the things that you know, people were curious about is like, okay, who do I hold responsible if this information is found to have been breached, right? Because one of the biggest challenges you have is nefarious actors aren't walking around stealing information and leaving thank you notes and saying, yeah, so, you know, I was here, I just stole the info, ha, ha, ha. I'm gone, you can't catch me. They're not doing that. So it's very difficult sometimes, if they're not leaving any digital footprints, to determine this. But if something like that should happen and it is discovered that from this vulnerability there was a breach, who do I hold responsible? Now, in the case of JamCOVID, it was an interesting question because the developer of the application was different from who the owner of the application was viewed to have been. So you had, the AMBER group as the developer of the application, but you had the government of Jamaica, who in this case, and as per law, would have been the data controller. All right. Now, and Chuck will jump in real soon because we had long discussions about this. One of the things that I was trying to explain to various audiences was that, look, when you talk about who is responsible, there are two people that are responsible, one more than the other because one has more liability and risk than the other. One, the developer of the application ought to have built something that had a particular level of security by design and so on. But the truth is, it is the client, in this case, the government of Jamaica's responsibility to ensure that what they have been provided with does not leave them open to the kind of litigation, perhaps, or whatever that comes along with being a data controller. Because in the case of JamCOVID, the developer was merely a data processor, right? But the government of Jamaica is the controller of the data because that is who you're giving your information to. You're not giving it to AMBER Group, you're giving it to government of Jamaica. And by the way in which our data protection legislation is worded, it is the controller that is held responsible if something happens, right? So if I, as a private citizen, said, I don't too like how this vulnerability jibber jabber thing did work, I feel that my data was compromised, right? If I wanted to hold somebody to account, I'm holding the government of Jamaica to account, not the developer. And that is because the data controller is who is responsible for making sure that my data is secure. Businesses that capture information, whether they put it on them website in a farm and then putting it in a database, whether they work at the hairdresser and you have your little Excel spreadsheet with name, phone number, all of these people now become data controllers because they are now in custody of people's, or what is defined as people's personal information. And as a result, as per the law, there are serious ramifications. If one, them don't treat with that data properly, they don't put measures in place to demonstrate that they're treating with that data properly. And if I decide that I want to challenge or report you because I don't feel that you are treating with my data properly, and that is what the law provides for citizens, the responsibility that the law dictates for businesses, whether they're private or public sector. Once you understand that, as a citizen, you now know what it is that anybody who has your data or that you gave your data to must do. Because the minute you feel that they're not doing that, you have a responsibility to yourself. And if you feel, that you have a bigger responsibility to the rest of the country, you have a responsibility to everybody else whose data they may have collected to say, look, you're not treating with my data properly. I'm going to, put in a report to the Information Commissioner, and then a process ensues. So I think, again, once everybody is aware, business-wise, and as a result, businesses need to ensure that they put measures in place so that when the information commissioner comes to you and says, listen, John Brown said you're not dealing with him data properly, you know. You can say, well, sir, here is how we are treating with the data, here are the processes we have in place, here are the procedures and so on. We feel that we're doing a good job. It is up to the commissioner to determine how far to take that. But again, for those instances to be triggered, you must know what companies must do. Companies must know what they ought to do, and you must know how far you can go. Some people feel that, listen, if it's a big company, I can't go even hope for challenge them. No, this is what this law is meant to address. And you don't have to go and talk to them. You go and talk to the information commissioner, and he represents you in your challenge of how these entities, whoever they are, big or small, right? Multi-billion to multi-thousand, right? And that is what the law provides for.
Oh, okay. Excellent, excellent. And it's he or she, unless the he's already hired. I haven't heard if the information commissioner is already here. But Matthew, you had your hand up, and then I'm going to actually take a couple questions because there are a couple questions that are specifically around this area of responsibility. Yeah, go ahead, Matthew.
So one of the, and this gets to your scenario as well, Stacey, and I was actually looking back at the Data Protection Act again today, and it came up based on the example that Chuck just also raised a while ago, in that one of the rights that we will all have in the fully operationalized data protection framework that has been proposed is the right to both provide and retract consent to the processing of your information, right? So in the same way, I mean, Chuck was kind of talking about it from a slightly different scenario where, you know, you can obviously report organizations if you feel that they're not processing your information in the way that it is, and that can initiate a process. But even in, you know, these one-off things, you know, the right explicitly provides that, you know, in the same way that consent must be explicitly captured from the data subjects to be able to process their information. It also provides a specific right by which the individual can retract that consent. The question I have, you know, and I guess maybe this is for Chuck and Georgia, is that interestingly, the law makes a distinction between the ability to retract consent from the ability to prevent processing. And it gives some specific exemptions by which you can say that you want to prevent processing of your data, you know, whether you perceive that it may cause some harm or that it's not accurate or some other, there are certain grounds that the law has. And so I wonder, you know, in a context where I have retracted my consent to the processing of my information, does that not necessarily equate to me preventing the processing? So I just wanted to maybe get you guys' thoughts on the distinction between those rights within the law. Yeah. Oh.
One of my legal experts, because I know that question was not for me.
No, man, I'll gladly jump in after Georgia.
Oh dear. Okay, so you know that there are these standards, as we started out by saying, for processing the data. So the first standard, which talks about processing data lawfully and fairly, and a subset of that, you will have the conditions for lawfully processing data, and one of those conditions is consent. But that's not the only condition. You also have legitimate interest for the performance of a contract, and vital interest in terms of health and so on. So what I always say to persons, do not rely on consent because it can be withdrawn. However, that nevertheless is a different, is in a different bucket from the ability to prevent the processing. So you the data subject. So these are your rights and the principles on which you are going to be processing data, and then there are the data subject access rights. So if you process on the basis of consent, yes, it can be withdrawn, and that's the end of that. But then the data subject, if you decided that you were going to process on a different basis, such as legitimate interest, vital interest, and so on, then what is activated in terms of prevention that you just speak about is a data subject access right. So there's a different distinction between the two.
I will go down that. I'm in 100% agreement with Georgia and flesh that out even a little more. Mm-hmm. So once the basis of processing is consent, as easily as it's given, it can be taken away. However, you do have the right to object to processing. The right to processing doesn't automatically, once you invoke that right, it doesn't mean that the entity has to automatically stop. They only have to automatically stop if it was based on consent. However, if it was primarily legitimate interest, it is then what the data controller now has to do is to now say, okay, we have an objection. We have looked at, before we started processing it, we did a legitimate interest assessment test. We looked at the purpose of processing. Why we want to process, we acknowledge that we are restricting your right, and we said, okay, we are of the view that this is the least invasive way we can achieve our objective, but it is a legitimate interest. So they will just inform the data subject that, hey, we have noted your objection, but we believe we have a legitimate interest in processing your data. And then that is when the data subject would now go to the information commissioner and say, hey, I'm not comfortable with this entity processing my data in this manner. And the information commissioner now has to make a determination whether or not your exercise of your legitimate interest outweighs the right to privacy. And that's where the balancing act is, because it is a constitutional right, and there will always be a balancing act between competing interests and competing rights.
And that's why, again, goes back to the awareness part, Stacey, because again, what both Georgia and Chuck have outlined is a real situation that could occur, but an uninformed citizen would never take it as far as now saying, I'm going to go to the information commissioner after all of this occurred. Because here's one of the things that always is missed in many other steps. And it goes back to a situation that I've talked to Matthew about with regard to transparency. If you don't know when or how somebody is processing your data, you can take an action to prevent what they're doing. Now, one of the things that is extremely important is for a data subject to be in a position to say, hey, what are you doing with my info? And they must get an answer, because the info being processed is not owned by the controller, although they may want to feel that way, because government tends to feel that way a lot. It is your data. Now, understanding that fundamental fact puts you in a completely different situation where you can now say, look, I want you to tell me what you're doing in my information. Please advise me. Now, there was a part in the data protection legislation that came up in many discussions while it was in Joint Select Committee, that if I decided to challenge how a company was dealing with my data, and the information commissioner made a request to that company, the company was obliged to respond in 30 days for that kind of request. And if they didn't respond in 30 days, there was a fine attached to it, but nothing else, right? Now, there was a school of thought that said, look, if I'm big enough, I will allocate a budget just to avoid responding to the information commissioner. right? Because the fine isn't that big. But the thing about it is that the citizen must be able to make that request based on the knowledge they have of how their data is supposed to be processed, by whom and how. And you know, even if a company decides that they're not doing it, which wouldn't be a really good idea, but it is possible. Triggering that sequence of events comes back to knowledge of your rights and what the law provides. So I'm going to sound like a broken record in this thing, because the whole idea here is, look, know what the law provides for you, because it puts citizens in a very unique and powerful position as it relates to the custody of their information and how they feel it is being handled. You may not always win the battle, but the thing is, know and exercise what is your right, and let the what I call it, the chips fall where they may, so to speak. But what that will do is, when you're challenging an entity will internally have to ask itself some questions and take some actions, whether they knew it or not, that they were supposed to do. So it is very important, if you're going to hold any entity, public or private, accountable, you have to carry the process through, not fearing, you know, what the outcome may be, because it is your right. And that is the you know, the fantastic thing about what the data protection legislation was meant to do. It gives you this right that you must be aware of. And
May I add a counter to that?
Yes, Georgia, please do. I have a few questions as well. So
Yeah.
I'll take your counter and then I'll go into the questions.
Right. I just wanted to add this for Trevor. So Trevor put forward provocatively as usual, this whole concept of an organization putting aside a budget to pay fines. But one of the things that privacy practitioners will tell you is that the incentive for compliance with the Data Protection Act is not only just about those fines, because reputation, business reputation is extremely important, and what breaches or potential breaches, even for the consumer, does to the confidence and reputation, confidence in the business and consumer trust, and the reputational harm that can come to the business. So when organizations think about it in the round, they are disincentivized, even without getting to the fine, from not acting in conformity with what the Data Protection Act is requiring. That's how it is structured. And to add to that as well, it is not so easy to suggest that you're going to put aside a budget for a fine, because as with everything that you go before the court with, you're going to have a first-time offender, a second-time offender, and then you'll get to the point where it becomes a serial offender. And those are factors which are also built into the punitive aspect and the consideration of the kind of fine that will be imposed in the Data Protection Act as well. So I'm just putting that on the table.
Okay.
No, absolutely, I agree. And again, like I said, it was a school of thought that came up based on joint select and let's come discussions, because the thinking was that, well, geez, these guys could do that. So I agree. Reputational damage, though I would posit that reputational damage is based on who knows what happened. Now, if people what happened, there is, if the leverage and leeway to make some of these things publicly known, then reputational damage becomes important. But if there's no knowledge of what happened, then, you know, again, it's it's a risk some people or companies may want to take.
But
which is where that discussion came from. So
I'm going to.
no, but I have to add this one, Stacey.
We still have trust to go through, and I have like 10 questions, right? So if you can in, and Chris's hand has been up for like 20 minutes. So if we can just
the DPO, the fact that the DPO is there is another factor. So there may not be an opportunity for someone to say. It depends on who knows what happens. Just saying.
Okay. All right. So Michelle from the UK, who is up with us late. Thank you for joining, Michelle. She's positioning a question about in Barbados, the Data Privacy Act has been enacted a few weeks ago, right? And is now enforceable. Does that now mean that if an organization loses personal data, are they accountable for the loss? I'm assuming the answer would be yes, based on everything that has been said so far.
Well, yeah. Well, assuming that the Barbados Data Protection Act follows the template that we all know that most of them follow, yes. Yes.
All right. Now,
generally speaking.
There's been a lot of conversation about the Office of the Information Commissioner, right? And I have a question from Sean, essentially asking, isn't this office responsible for moving this process along? Would that entity not have to be formed in order to support, and I'm adding my little 2 cents to the question here now, to support the actual enactment of the act, or is it that the Office of the Commissioner comes into proper functioning afterwards? Like, is there an order to it? Is there a support system that will move it along through this office being there? Anybody can take that?
I think Chuck is going to take it.
Yeah, thanks, Georgia. The critical role the Information Commissioner has to play at this stage is really that awareness, both of the data subjects and their rights, and awareness to government entities and private entities as to giving them guidance as to how to implement these data protection compliance programs, because there's nothing intuitive in implementing a data protection compliance program. The information has to come from somewhere. So the first responsibility of our Information Commissioner's offices is really to make the members of the public aware of their rights, and 2, make information available publicly, technical information to government entities and private entities. What does a privacy program look like? But if you're to ask a question, if the data subjects cannot exercise any of their rights in the absence of an Information Commissioner, the answer to that question is no. We are speaking about a constitutional right. And once you have a constitutional right, you can seek redress before the constitutional court.
Okay, that's
there's another thing I need to add about the Information Commissioner's office. One of the functions of that office and the officer is to develop regulations around the legislation that will be there. And regulations are very important. And we tend to, in government, develop law without regulations. And one of the challenges that creates is the ability to enforce some of the things that are in the law. So the Information Commissioner's task is also to develop regulations that will allow, for more granular enforcement, so to speak, because the law is very broad in what it states. When you get into the nitty-gritty now, it's regulations that are important. And we tend to create laws without regulations, and laws, they're great, but the enforcer has a problem enforcing because there are no regulations behind that. So that's one of the key things there. The other thing is, yes, the office needs to exist because it is important. It's part of the law. The law says that office must exist, right? So even though, you know, you can go to the Constitutional Court and challenge, this provides a slightly different avenue, which I would say is a little bit more down to earth for the common man, so to speak. That because, again, the common man, you start talking about Constitution and Constitutional Court, they say that's up here. We don't know about that, right? But if you present to them that, look, if you don't like how a man treating with your data, you got to this guy over here, tell him, and we sort it out for you. That's what the Information Commissioner's Office is meant to do. And that office, as Chuck has pointed out, has some very unique powers, so much so them can lock down business. Them can put companies out of business if they're not compliant. But, you know, I look on it as that office and that officer is my advocate for my rights. He is the guy I can go to. I'm gonna have to pay him, by the way, to go and find out what I want. Some people have a natural fear of going to a lawyer to do this, which is what they'd have to do if they're going to Constitutional Court and all of that. But here is a guy, or an entity, guy or girl, entity that I can go to defend my thing. That is what the law provides, on top of saying that you are in control of your data. You have a right. And oh, by the way, we're giving a place to go for redress if you feel your thing not being dealt with properly. That is the important aspect of that office, which is why it needs to be there. So yes, educating the public, and creating regulations, very important aspects of that office, because that is where the common man goes when he have a problem. If that office not there, some people just not go, and that cycle of trust and management of my data gets eroded again, because now I don't know where to go. I don't know who to go to when I have a problem. Yep.
All right, awesome. Thank you for that. I'm going to combine this question from Kelly, and essentially it is, with no knowledge of whether data was extracted and no way of knowing, shouldn't the government have notified the data subjects as a precautionary measure? Between the public article and rectifying the vulnerability, can we actually say whether or not a breach didn't happen? So shouldn't there be some kind of, you know, based on what we discussed so far, they don't have to. Shouldn't or shouldn't they? You know, I don't know. But just a quick answer to that, please, and then I'll take Chris and we'll continue, because I have one more angle that we need to focus on.
They should have.
Okay, thank you. Anybody else? They should have. Got it. All right, Chris, you had your hand up.
Hi, good afternoon, folks. I think I have to blame Chukwuemeka Cameron for this. He spoke about promoting, and I don't know, somebody accidentally pressed the panelist button and I was promoted as panelist. Not sure, but since I'm here, I said, well, let me make some mischief and ask a question and also pose a scenario. Matthew, I heard you loud and clear with respect to your 2 years. A number of us are out there warning and telling people, get ready, do what you need to do now. Don't sit down, wait. We're not in a waiting thing. Just pretend that the law is enacted and gazetted and signed and whatever other words you want to do with government. And so that is one, that's one thing. Now, there's this thing that I've been doing, like reading and researching, because as we have these type of panels and talk about these things every now and then, sometimes you have to kind of throw up a devil's advocate position. And I noticed that there is a wide-ranging global conversation about the privacy paradox. And I would like, not today, Stacey, but at some point in time, we also engage in just kind of our take on this privacy paradox. In other words, these laws are here, people are saying one thing, but their actions are actually totally opposite of what they're saying. They're installing devices, whether it's IoT devices, they are turning on features on their phones, whether it's Siri and OK Google, and they're doing all of these things that are extracting massive amounts of data from them and they know that it's happening. But at the end of the day, you know, I said, okay, Google, and see what happens. It starts to search what I'm saying a while ago. And so, you know, there's just this other component, and Trevor here loud and clear that yes, that guy or gal over there is the one that understands all of this, and that citizen who doesn't understand all of this, but is giving away gobs of their data every day can go to. But is all of this just for us as practitioners, us as technocrats? And for those of us here who have children, they're dumping all of their data into their devices every single solitary minute. I mean, you know, one of my daughter's rooms, they have this fancy, when I went in there, I was like, where did you get this from? You know, Grandpa gave it to me. This fancy Facebook device that's a screen, and they can talk to it, and they literally, if all of their friends have one of these devices anywhere in the world, they can just pop into their friends' rooms without no approval, no nothing. It's there. It's in the room upstairs. You want to come visit me? Trevor, come check me and I'll show it to you. It's a Facebook device, right? That is a piece of hardware device. And I'm scratching my head. I'm like, what am I wasting time with all this data privacy stuff? When my children, they don't care, right? So that's just my, you know, counteraction, devil's advocate, just kind of wondering aloud. Privacy paradox, you know, should we have some discussion around that also?
So it goes back again, Chris, to what I was saying originally. Awareness. Awareness starts with us, and then it needs to flow down to our family members or colleagues and so on, because again, and that's why, you know, events like this are really great, because a lot of times,
Trevor, they're great for us, right?
Well, no, and so this is what I'm saying.
I don't remember who saw the documentary on Netflix. There's a documentary on Netflix that took us through the whole thing. I brought the family. I sat them down. I said, girls, watch this. Halfway they got up. They're like, they don't care. George,
yeah.
And my kids did as well. And we watched the entire thing. And I took away the phones while they were watching it, so they didn't have anywhere to go. But the discussion afterwards was like, well, we all know, but it's no big, it's just the way it is. There's no, you know, thought process about it, right?
But the thing about it is, and again, I have to challenge that, because I think what is important is, okay, they know, we all know. There are a lot of people who know or don't know. A lot of people don't know. But one of the things we're not doing is we're not effectively educating people about the ramifications of the space that they're playing in. So let me give you an example. About 4 years ago, so I used to be a regular presenter at the National Cybersecurity Conference up at UWI. My third presentation, I was asked to do a demo. And I chose to do a demo of a live hack that mimicked an incident that occurred on a number of government websites. So I recreated the actual hack that occurred in front of the crowd, right? And the thing about it was, what I realized was, is one thing when you tell them about it and, you know, you're talking about what happened and this is what could happen and so on. It's another thing when you show it to them in front of them face and they see it and they see the breach occur. They see the hack and they're like, hold on, is that real? Because when you show them the ramifications, a whole different story. Kevin Mitnick does that, right? Kevin Mitnick shows you how he goes about stealing information from people in a bathroom stall, right? When he's doing infiltrations into companies. It is not until people see it. So effective education and awareness. I don't think we do enough of that. So like for my son, there are times when he gets a little paranoid because I actually show him some of the effects of the craziness that he does. So now he gets very paranoid, picks up the phone, calls me, all right, daddy, did you do this, that? Did you buy something on the Xboxes? And again, it is how we convey that message. Everybody knows what's going on. But you know what? When I tell someone, like, again, did a presentation at UE, I asked, you know, who has a smartphone? Everybody, right? And this was based on the pre-NID situation where people were having a big brouhaha about fingerprints, right? I said, who has a smartphone? Everybody puts their hands up. I said, okay, great. Who has some of the cool smartphones, like, you know, the Apples and the Samsungs that allow you to open your phone with your fingerprint? They're like, oh yeah, we got that. I said, let me ask you something. Do you know where your fingerprint goes when you put it on the phone in order to unlock it? Have you ever considered what happens to that fingerprint? Do you know how that works? And the looks on people's faces were like priceless to me, because no, they're like, hold on a sec. I say, yeah, you're here going to argue about who you're giving your fingerprint to, yet you are placing your fingerprint on a device that sends information, which you know it sends, to Google. You don't even know where Google is, right? Now, do you know if Google is capturing your fingerprint? Do you know how it works? What you do it. And just by saying that, their entire meds changed, right? And again, sometimes shock and awe works, but it is how you convey the message that is important if you intend to have people get it, right? So in much the same way that, you know, we have to let people know that, look, vulnerabilities are gonna happen. They happen every day. Breaches are gonna happen. They happen every day on a gargantuan scale. Okay, get over that. No, how are you going to deal with it? All right, because again, people don't understand the level of breaches and vulnerabilities that exist, right? But we don't show them. I show people, you know, in my office, 6 global threat map screens, and they look and see threats occurring in real time, and they're like, oh my God, I didn't even know that was what happens. I say, yes, this is what happens every day. This is happening right now. Puts things into perspective. So it's how we go about conveying the message, and we have to do it over and over again. Beat it in, and once you do that, you know, and I don't think as practitioners we do enough of that. But things like this, and you know, people who know need to get out there and start talking about stuff, sharing that knowledge, conveying this stuff, because if you don't do it, people are going to be oblivious. And that is when you have very successful phishing attacks, because somebody was not made aware of the kinds of things that can happen if you don't think about clicking on a link that you know nothing about.
Okay,
You know, so.
All right. So thank you so much for that riveting discussion. We're going to have a separate session on it, Chris. I think it's worthwhile, in particular if I'm supporting the points that Chukwuemeka and Trevor continue to raise, that we have some work to do in ensuring that people are aware, right? That awareness piece needs a little bit more traction. I do want to encourage my panelists also to please check the chat, because I do have a few questions in there. So please feel free to check the chat and respond to persons that have posted questions directly. There's one that Andrew has put in about the feeling that I think Trevor mentioned earlier. If somebody can actually be, the controller can be held to account based on a feeling. But Matthew, you had your hand up. So did you want to add anything before I moved on to the trust conversation? Because that is really where we're going to be wrapping up. And it's quite a provocative, as Georgia said, quite a provocative topic.
Very, very, very quickly. I think, you know, just building on the points that both Trevor and Chris mentioned, I think, you know, there are 2 pieces of it. One that came to mind that wasn't discussed. I think one is that there's a complexity that comes with digital technology that the entire world is grappling with it. You know, we talk about Facebook and the things that happened with Cambridge Analytica, etc. There's a part of Facebook early in that didn't even really contemplate that their platform could have been used in the way that it ultimately became used for, in terms of undermining democracy and all this and all this sort of stuff. And there's a way in which, you know, the challenges that we're grappling with now in terms of what the broader digital transformation of the world that is taking place, you know, we're still, you know, as a society, as different countries, as a global community, and as a national country, grappling with what does this all mean? You know, notwithstanding the fact that the legislative framework is not even anywhere near to catching up to the pace at which those things are happening. And then I think the other piece, and this is part of the challenge with some of these services, is that the service design experience and the product experience can obfuscate the risk of those services. And that's a big challenge, you know? And so, you know, and that's, you talk about that Facebook service, like, oh, it's why should I care? But, you know, the other side of that is what happened with WhatsApp earlier this year, where someone at Facebook decided it was a great idea to tell 3 billion people at the same time that the policy is changing and we're going to share your data with Facebook, right? And that completely blew back, you know, at them, because people are just like, we're not into that, you know. No, the question as to what will ultimately happen. And to be quite honest, the aspects of the policy change that were introduced there weren't that, you know, significant, but that's another conversation. But, you know, it was just the service experience of the unrolling of that policy change were terrible from like a UX UI perspective. And that created a significant amount of harm for them as a company and for that service. So it's hard. I don't agree with it that, you know, it's, you know, I think it's something that we have to fight, as, you know, as Trevor had mentioned, and I have to keep kind of preaching and then also engaging with the actors that create the frameworks in which we exist. Over. Back to you, Stacey.
Awesome. Okay, thank you for that point, Matthew. And with that, I wanted to segue back to the final context space, which is trust. And this is something that Georgia raised in our prep yesterday, and I thought it was a really great point to actually really anchor this entire conversation in, because ultimately persons were looking for somebody's hand to be slapped, or, you know, and that tends to be what happens a lot of times, is people are looking for somebody to be held accountable, or they're looking for, you know, some kind of payback. But the truth is that we're going to see much more of this happening. And with so many different systems coming online that are, you know, promoting e-commerce on a national scale, we now have a new platform, ENDS, and just a shameless plug, we're going to be doing an ENDS journey, a journey upon the ENDS right here in our JTDA forum in another couple of weeks. But with all of these new systems coming on stream at a national level, and you know, you see people still not trusting, and we have NIDS bill that is now there pending, and a lot of work being done by the various coalitions that we're a part of, and everybody in this on this panel has played some role in this process of renegotiating NIDS, at least that's what I'm calling it. With all of that looming, you know, what is the role of government in rebuilding trust? Because I do believe that trust has been eroded. There has, to put it in the way that Georgia framed it, she does so wonderfully with these words, they've lost some ground in building trust, right? What is the role of government in building trust so that we can advance confidently as a digital society, and so that from the pantry man and security guard to the persons running the millions of billions of dollars banks, etc. Pretty much saying that it's the banks that are making the billions of dollars. But from every end of the spectrum, that we can have that confidence stepping into the digital society space. And I'll open up with Georgia if you want to weigh in on
that. In 2001, when I did my master's at University of Toronto, one of the texts, one of my professors, I studied from the law and economics school in terms of how economic principles can impact law. And one of the texts that he had was this whole concept about the prospects for reinventing government. And I've always been attracted to that topic from the time that I came across it, the prospects for reinventing government. And what they really mean by that is, if you think of government, government is all about, generally speaking, about secrecy, bureaucracy. They are traditional. They don't readily give you information, and different departments of government are different, or the same department, but at different locations, giving you the same information, different information, therefore causing a lot of mistrust. This whole online space and e-government that we have been hearing about, it gives government an opportunity to change that. But in order to change, so government wants to get online, and government wants to do this e-government so that everything is available in a single space. But in order to do that, they have to build this whole idea of trust. And it's now not just about trust as a matter of suspicion, but that's where we get into this whole idea of people need to feel sure that if they give their information to the government in an online space, that it is secure. And I believe that that is where a lot of the issues. So you had asked this question earlier about whether, or someone, I think Kelly asked the question about whether in relation to the JamCOVID incident, government, who should have communicated, or whether they should have communicated or notified. And I say that even though we do not have a data protection environment, in terms of the bigger picture, and with needs looming in the background, and the suspicion and the general suspicion in relation to government, some communication could have taken place, because government is starting from a position where persons do not trust government systems or government actors. So it's in that context that I said, to the extent that they were gaining ground, they would have lost some ground in terms of building trust. You know, Chuck likes to use examples, and as I'm speaking, one of the examples that just came to me, if you are watching the Chauvin trial going on right now, and then almost next door, a 20-year-old was shot and killed in what they say are accidental circumstances. For that officer, what do you say could not have happened at a worse time? So it is in that context, when you look at what happened with JamCOVID, it's not that we are not in that environment, because even last year between, say, Teams and Zoom, you heard a lot about this Zoom bombing and so on, and risk naturally to personal data. But they have recovered. So we know that we are going to get there, but it could, given the mistrust of citizens to government, irrespective of the efficiency that we are going to get, it could not have happened at a worse time, given that needs is being discussed in the background.
So just to piggyback on that, like I said, in my simple answer, they should have said something. I think the whole situation was very badly handled, but I think that is because there was not sufficient understanding of how you handle situations like that, right? So you don't PR away something like a breach or a vulnerability incident in the way that you would PR away some other types of events, especially when you are not in custody of all the information that actually exists. And I think the lesson that should be learned from what happened is, again, acknowledge that vulnerabilities and breaches will occur. They're going to happen. What you need to have in place is a method of responding when it happens, right? So with Zoom and Teams and everybody, the general public knew everything that Zoom was doing to fix the problems because they told them. right? But when you see press releases coming out, instead of saying, look, we acknowledge that something happened and we're doing everything we can to get to the bottom of it, including engaging the people who may have discovered this, versus saying, well, we might have to consider, criminal proceedings based on what happened. It's a very complex situation, because in the context of the government being constrained by its own laws, because the Cyber Crimes Act almost forces them to have to take that kind of stance. The thing about it is this: look, it's not everybody out there I try thief things. There are actually people who are looking to ensure that the technology is safe so that more people can use it, right? So if you don't realize that these forces of good are out there, and then you start to take adversarial, stances. And I think it is very important that we understand and create procedures and processes that understand the environment and ecosystem out there, because a lot of companies do not understand the ecosystem that is security researchers, ethical hackers, white hats, and also the nefarious ones, which are black hats. A lot of people don't understand those ecosystems and what motivates these people to do what they do, right? So in an instance, somebody who is trying to help you, you rub them the wrong way, you'll step back and you'll really see what problems you could have, right? So you have to kind of understand and function within that kind of environment and context and engage. So think about what would have happened if, when the government was made aware that the government engaged who may have found this vulnerability and said, all right, great, thank you for telling us. Is there anything more you can provide and help us with this? And say, look, you know what? Something's not right. We're doing what we need to do to get it fixed. We acknowledge that vulnerabilities will occur. We don't know if breaches have occurred, but we're doing everything to determine this, and we're working with as many people as possible. When you start to put things that way, it appears as though you're working with the interest of the people whose data may have been at risk. You don't know if it was at risk, but the message that you're conveying through your statements is that, listen, we don't know what really happened. We're trying to find out, working with everybody to do that. And once we find out, we'll let you know. If you don't tell people, that is where the trust starts to evaporate. We don't do a good job of informing people when bad things happen as to what we're doing about it. Because, I mean, banks do it, other big companies do it. You hardly hear about the breaches that occur in banks in this country.
Yeah.
Right? Because again, Georgia, it goes back to reputational damage. Well, they haven't had any reputational damage because nobody don't know, or the general public doesn't know, which is why reputational damage, it depends, because it depends on who knows, right? So when you talk about engendering trust, one of the critical factors in engendering trust is just telling people. Just telling people. So when you look at needs, when people have their information, which they grudgingly give to government because, of how the thing is taught to work. Think about what would happen if you could tell every citizen every time somebody accessed their data, what that would do. They didn't ask you to do that, but you tell them, right? And, just because somebody accessed your data, we're going to tell you, right? No, they can't say that, boy, I don't know when I'm going to access my data, so somebody must be doing something bad with it. But if you tell them, that argument is gone. Transparency. That builds trust when you tell people things, right? And the technology is there to do it, right? And that's the kind of stuff sometimes we need to focus on, because when you're rebuilding the trust, a lot of it is simply letting people know what's going on.
And on that point, Trevor, I think there's still even opportunity for that. even at this stage, because it's still an active space and it will continue to be an active space. And I'm going to toss to Matthew with your hand up, because I know that the NIDS discussion is now alive again. And that's one, having had such a major challenge with the erosion of trust from the first go around with NIDS. You would think that a lesson would have been learned to the point where we now have, would have sought out support, wider support, to get advice, right? So what is being done differently this time around? You know, if anybody can weigh on that, Matthew, I'll have you go first, with the implementation of NIDS that is going to really shift that needle towards gaining trust versus losing ground, as Georgia put it. And after you, then Chukwuemeka can weigh in.
So this is not where I was going to start today, Stacey, but you asked me to provide some info, but it's an important one. No, I think, you know, this phase, and I think we have to give credit, and this is something, you know, in my contributions to the Joint Select Committee I shared as well, is that, you know, the first thing is that the government made a statement, they made a commitment that they were going to take this NIDS bill through Joint Select Committee and allow the public to comment on the bill and to hear that feedback on the bill. That was something that was done in the first one. And I think that's such an important part of the process, because it opens up the consultation and the engagement process in a way that did not exist before. So I think that's a first and important one. There have been some stakeholders that have been, and industry persons that have been engaged in the process of the design of the, you know, different conversations in the design of the bill. I won't make a valid claim about how broad those consultations were, but I do think that there appears to be a recognition and an effort to try to do some of that better. The bill, in my opinion, is a better version is better than the one that we had the first time. But there's some important things that the bill does not contemplate and does not sufficiently address. And we've made some of those points. And I think this is where the other part of the rebuilding trust comes in. And I'll stop quickly so I can hand over to Chuck. I think one, you know, designing in the open is such an important part of building trust and transparency around that. So one of the things that we've asked, and I know, you know, working with JTDA on this, we're going to try to raise some more, is that, you know, other digital ID projects have done things like publish white papers, have published the technical specifications of how the system is going to work, have published information about the architecture as a way of encouraging, you know, private practice and the industry groups to be able to look at these things and raise these points and be able to critique and provide feedback. That kind of consultation and that kind of transparency is not yet reflected in what we're doing in this first part, this second version of the NIDS process. The other one is around, well, what is the posture from the government when points are being raised about weaknesses in the bill? Is it immediately well, I have to defend this because I don't really want this to go sideways? Or is it an acknowledgement and an affirmation that, well, we're in this Joint Select Committee process. This is something that we did not contemplate. Let's see how we can address this. Can we invite you to come and talk about this some more? Let's engage around that. Those things lend themselves to building trust and building dialogue. And I think that's what we'd like to see. That's what I'm hoping that we'll get more of. And I think those are ways that we can do a bit of the trust building. Over.
So on a high level, outside of the NID situation, the Data Protection Act is really a gem. You would have, and the very context of this conversation spoke to accountability, and Georgia did a beautiful job at identifying some of the main tenets of the legislation, and I think it's a good time to repeat the tenets of the legislation. The primary obligations of data controllers are to be transparent and accountable. Transparency and accountability equals trust. So if we were to step back and seek to implement the infrastructure that the Data Protection Act dictates in terms of establishing that Information Commissioner's Officer. So you know that, just like what you hear Trevor suggesting earlier, if you have a problem without somebody processing the data, you know that you can go directly to this person and this person will look into it. There is some means of recourse. If it is you were to empower the citizen and let them know, hey, we are processing the data, but you are in control. So you don't need to walk with them every step of the way. You may not have the foresight to go as far as Matthew is suggesting, but if you let them know that, okay, you are not a lamb to the slaughter, you are empowered to hold us to account. There are accountability mechanisms in place. I'm of the view that helps put in real infrastructure in place to build trust is what counts. When you look at the structure of the net legislation itself, I want us to, well, my personal view is that in light of that decision that was handed down by our constitutional court, the needs they have sought to really build in on a technical level and even on an organizational measure level, the requisite security measures. What is absent in society and what is absent in the needs situation itself is that appreciation of that right to privacy, that appreciation of each person that, this could be cartel shoes, and the fact that I am responsible for cartel shoes. So good, moving away from the technicalities and the organizational measure and the security, we need to appreciate that it's not just things that we have to put in place because the Constitutional Court said so. As long as we start creating and adopting among ourselves that culture of privacy and people understand it on the various levels, I think we can start moving towards that trust that is important for any system like this to work.
I just wanted to add something. And again, here's a situation where government doesn't do enough to tell people about, So, and this is really a comment based on, what Matthew was putting forward, because, the Joint Select Committee situation is extremely important. It was not done before, and it is a major shift from what transpired. You will notice that there was a Joint Select Committee for the Data Protection Bill. There was no question about whether that had to happen. One of the things that the government has not done well is to let people know how many consultations they've had. So I bet you couldn't tell me how many consultations they've had as it relates to NIDS. I have a list of all the people that consulted with, all the agencies and entities, and it's about 200 different entities that they consulted with on this particular bill. But I'm not telling nobody that, right? And the thing about it is, when you're looking to again demonstrate over and above a public Joint Select Committee that in itself is meant to unearth and demonstrate some of the gaps and get stakeholder feedback. Some of the things undercovers are not talking about. There's a lot of technology you're incorporating. I don't tell people about in NIDS. And I think, again, being transparent about this stuff and telling people what we're doing, to make your data secure, to increase that transparency, goes a far way in engendering that trust. Because if I don't know what you're doing with the data, my first thought is that you're doing something bad with it. And therein lies erosion of trust. But anytime I tell you what you're doing, I mean, think about a situation where, you know, again, if I knew every time somebody ran a validation against my information in the NIDS database, if I got a you know, just like how when a transaction occurs in my bank account, I get a text message, all right? Well, what would that do for trust as to what is happening to my information in NIDS if I got a text message or an email saying, oh, this entity validated your information 2 days ago, right? And you can be like, oh yeah, all right, cool. Or like, hold on, what them touching my data for? I don't have no business with them. That's like when I get emails or text messages from Singer, I'm like, I never give Singer my phone number. Where them get that from? But the thing about it is when you tell people, right, without them asking you to tell them, when you just tell them, and it's not a volatile thing, just tell them that, look, your thing get access, here's when it got access. You know, you tell them, and who access it, you tell them nothing more. And after that, leave it to them to figure out how they want to act. Once you do that, and of course, there are exceptions and limitations to when you do that, right? But generally, tell them. That's how some of this trust comes back into the thing. Tell people what's going on.
And I do want to underscore the conversation that has been raised about NIDS. Thank you for that, Trevor and Matthew and Chukwuemeka. That we do have a NIDS deep dive conversation that's going to be happening in a couple of days with UTech's skit, right? So we're expecting that that is going to be quite a vibrant conversation as well. As it relates specifically to the NIDS bill. Matthew, you had a point. I do want to wrap up because we are about 20 minutes or so over our usual closing time. But go ahead, Matthew.
Sure, very quickly, just on the points that both Trevor and Chuck mentioned. I mean, I think, you know, the trust thing is so important, and I'm behaving myself this evening in that, you know, on the data protection, it's important to tell the whole truth, even when it is inconvenient as well. And I think the government does have a bit of a conundrum that has been raised, and I don't know how they're going to solve this problem in the immediacy. So one, that, you know, there should be no question that the Data Protection Act needs to be brought into force when it comes to the processing and the operationalization of NIDS. The Joint Select Committee chair has acknowledged that, in fact, there are a number of things in the law that make reference to the Data Protection Act, and in his legal view, that means that that must be brought into force. Now, one of the inconveniences is that, as we've discussed on this forum, that the Data Protection Act also has a 2-year transition period by which any individual data controller itself has to become compliant with the obligations within it. And, you know, that is an open question that has been raised, that that transition period, and this is one of the things that we put forward in the submission from the coalition that the JTDA is a part of, is that transition period shouldn't be applicable to NERA. NERA from day one should be required to be compliant with the Data Protection Act and all of the standards and the obligations that it has in relation to it. And I mean, I feel very strongly about that. And I think, you know, that's in the discussions that we've had at the JSC, I don't believe the government has yet a on the record position as to how they are going to engage with that problem. Because 2 years is a long time to say that you're going to, you know, wait until the NERA starts doing their work. But I think, you know, to the point that these are the things where trust matters, because it has to matter when it's both convenient and when it is inconvenient for some purpose by which you're going to be pursuing. Over.
Excellent, excellent. Okay, guys, so I do have to wrap because of time more than anything else. This has been an epic discussion. I want to thank my panelists for joining us this evening and for putting forward some very provocative thoughts for all of us to really examine how we are being responsible and accountable as individual citizens, as business owners, and as contributors to the forward movement of becoming a digital society. I encourage you guys to tune in. Lots of applause coming from the audience. I encourage you guys to tune in to other upcoming webinars that we have. As I mentioned, this week we have UTech's deep dive on NIDS, and then in another couple of weeks following this series, we're going to have a conversation around the journey upon the ends. I know that one is going to be a really hot topic. Looking forward to seeing you. Thank you, my panelists. Have a wonderful evening, rest of your evening, and an amazing rest of your week. Take care, everybody.
Thank you.
Thank you all.